Good afternoon. I'm Benjamin Sanchez. Welcome to another edition of Legal Grounds Live. I'm a Texas attorney. I help empower and represent people when problems arise in the two most important roles of their lives, as a family member and as a consumer. Today we are doing day 3 of the 12 days of Christmas, and specifically, I'll be going over case studies today. I just kind of wanted to let you know that I've been practicing for 23 years and I've had thousands of cases in my career. In fact, at one point, I was the highest debt collection filer for cases in the state of Texas for 2 to 3 years there. However, a few years ago, around 2012, 2013, I switched sides and I started representing consumers and debtors and defendants rather than big banks, creditors, corporations, debt buyers, things like that. So I'm now on the other side, and I learned a lot while I was representing the creditors, but now I use that to my advantage in representing debtors and defendants. Um, what I wanted to talk about today is a case study, and this is going to be my first ever case study. It's a case study about debt defense. And during this video, I'm going to be sharing my screen. So why don't we get to it? So this case study is about a typical debt defense case. This is a case that I recently concluded, and it actually concluded in my client's favor. And we'll talk about exactly what happened. Now, in typical debt defense cases, most cases are won by the creditor or the plaintiff because the defendant doesn't answer. And this goes back to a prior video in which I said the number one thing you should do is answer the lawsuit whenever you're served. The worst thing you can do is ignore the lawsuit. So, again, when you get a debt lawsuit, go ahead and answer it or hire an attorney to answer this case. Now, in this particular case, we will talk about, let me see here. Sorry, folks. So, in this particular case, it was a big bank versus an individual defendant. It's a credit card case, and the big bank is actually the original creditor in this case. So this is not a debt buyer case where someone bought a debt and is now suing the debtor. This is really the original creditor after going through collection efforts, finally suing the individual credit card holder, the debtor. Now, this is important. In Texas, you have 4 years to sue on a breach of contract case. So if the account is big enough, and big enough is relative, but if the account is big enough, then the creditor has 4 years to sue and usually will sue. What is big enough? I mean, I've seen cases as low as $900 sued on. I've seen cases obviously for a lot more. In this particular case, the debt was between $8,000 and $9,000, and that was big enough for the bank to decide to go ahead and sue the debtor after pre-suit collection efforts failed. Uh, so I think this is a good case study because there's nothing really unique about this case. There's nothing that I think it'll be applicable, and it's a good learning tool. Now, I will say this: the individual client that I represented actually was a pro bono client. And what that means is that I happen to represent that client for free. Most of my pro bono clients that I do have usually come from an organization that screens them first so that I know that they're deserving of, so to speak, a free representation because they don't make the money, don't have the financial means to hire an attorney. Obviously, we wouldn't want to have someone who makes six figures be able to hire an attorney through legal aid or some nonprofit if they can actually afford it. So most of my pro bono clients come through, for me, the Houston Volunteer Lawyers Program, and they come through that organization, and I pick up cases through them because I know that the Houston Volunteer Lawyers Program has screened them. Now, in this particular instance, however, this woman found me not through an organization, but she presented herself and asked if I would take her case. On a regular basis, not often, but on a regular sort of routine basis, I will take private pro bono cases that are not pre-screened. But of course, I end up doing my own screening to make sure that the client really is indigent and needs legal representation. I also have to make sure that the case itself sort of matches what I do and my qualifications. So I'm, of course, not going to take a products liability or a personal injury case, on a pro bono basis. But debt defense is right up my alley. So there's not a whole lot of extra learning I need to do for a case like that. So I decided to take this lady's case pro bono. So why was she being sued? She was being sued for credit card debt. And quite frankly, as you all know, there are a number of reasons why we get into debt, why we ultimately can't pay the credit card that we intended to pay. It could be sickness, it could be loss of a job, especially obviously during the pandemic. Things happen like that. There are any number of reasons as to why a credit card ultimately isn't paid. Most people don't go into a credit card situation with the idea that they're going to not pay. So, as someone who represents people all the time, I see the goodness in people, and I understand that we all get in situations where we get over our heads, and we shouldn't hold that against people just because they're in that situation. So let's go over exactly what I did in this particular case. So there were basically three things throughout the life of the case that I did, and I'll go over those sort of briefly. The first thing is what I told you is I answered the lawsuit. Now, although I told you before in another video that you should do a general denial, when you hire someone like me, I end up doing more than that. There are verified pleas, which are basically statements in defense that could be done under oath, or they're required to be done under oath as part of the answer. I've also done affirmative defenses, which are basically reasons as to why the defendant is not responsible for the cause of action or the claim by the plaintiff. So there are a number of affirmative defenses that may be available in any given case. And a lawyer who practices in that area of law and knows what they're doing will know which affirmative defenses to assert. In addition, within that answer, I also requested a jury trial. And I think a lot of attorneys end up doing a disservice to their clients, especially in the areas of credit uh, lawsuits, collection lawsuits, and evictions when they don't request a jury trial. Because, quite frankly, it's not a knock to the judges, but judges see so many of these collection lawsuits and so many of these eviction lawsuits. And so they see these over and over and over again, and they end up getting sort of immune to a case by case analysis because one case bleeds into another. And especially if there are no real crazy facts involved, the judges sort of get immune and they generally side with the creditor, they generally side with the landlord. So in these kind of cases, I like to request a jury trial because if we're actually going to go to trial, I really want 6 to 12 people um, who may understand the human condition and how we get into debt and possibly understand the defenses that I'm raising. A lot of judges just by nature end up blowing off the defenses as lawyer tricks, but I think juries really do consider the defenses. So I do request jury trials in my debt defense cases and in my eviction cases. So that was the first thing I did. And again, that's very important. The second thing I did was I issued discovery. So, what is discovery? Discovery basically is where one side gets to ask the other side questions. There are different forms of discovery. There are some basic, what we call disclosures, where certain basic information about the case upon request must be disclosed, although that's going to be changing soon next year. And I will be doing a discovery video, a CLE actually next month to a paralegal group. But generally, there are written questions that can be asked. Uh, there are answers that must be done under oath if you have interrogatories. There are requests for productions, which means that you get to ask for documents and the other side has to provide those documents. There are also requests for admissions where you ask the other side to admit or deny certain facts. And again, the basic disclosures, and then also depositions. You can take depositions of a corporate representative if a company has sued you, or obviously other witnesses. But generally, in this case, without giving too much away, I did issue discovery in this case, and therefore I made the other side work the case. In other words, they weren't just going to get a free pass on this case. Um, and then the other thing after I issued the discovery is I explained and proved my client's hardship. This particular person happened to be older. That person was on disability and unemployed. Now, it's one thing to say it, but it's another thing to actually prove it. So, what I did is I made sure we got proof of the disability that the client was receiving to show that she was not employed, she was unemployable, and that she was on a fixed income. So again, I explained that to the opposing counsel. I also gave them proof so that that attorney could then take it to their client representative at the big bank. And they were able to show that client representative who ultimately makes that decision as to what to do with the case, to do. So what did this do for the bank? What the bank saw was that this client had an attorney who knew what he was doing. The bank saw that there were defenses that were raised. The bank saw that if this case were to go to trial, it would have to be a jury trial, which is a different beast and is not sort of a quick run through. The bank saw that I was making their attorneys and their representatives work the file through issuing discovery. And then the bank saw that I was being genuine about my client's hardship. And so this wasn't a case where we were just trying to get one over on the bank, but that my client truly did have a hardship. Ultimately, all those factors come into play because the bank, as almost any creditor does, and I can tell you from having done thousands of these, most of these cases come down to an economic decision for the plaintiff. What's the likelihood of obtaining success versus the obstacles that are put up? What's the economic impact of going forward with this case? Will this case be more expensive than it's worth given the circumstances of the case? Now, this case ended up taking almost 2 years. So when I talk about these things here, these are not done all in a day or a week, but this happened over time, and it happened, with a lot of communication going back and forth, a lot of motions and pleadings being filed. But this is generally what happened over the course of a almost 2 year period. So what happened at the end of that period? The case was dismissed by the bank. Technically, For the lawyers out there, the bank dismissed the case, non-suited the case without prejudice. What does that mean? The bank filed a document that told the court that they wanted to drop the case. Without prejudice means that they dropped it with having the ability to refile. So you have to understand without prejudice means without prejudice to refiling, or with prejudice means with prejudice to refiling. The bank dropped the case without prejudice to refiling. So you think, well, that's okay, but the bank can always come back. Well, guess what? By the time that this end of this 2 year period had elapsed, the 4 year period of statute of limitations I talked about earlier had already elapsed. So even though the bank dismissed this case without prejudice, in essence, the bank could not file that case again. So this case was ultimately dismissed, and the client was able to walk away from this case without owing the big bank any money. Now, obviously, not every case is like this, but this is a typical sort of vanilla credit card case. What does this case show? Well, this case shows that if you have an attorney who knows what they're doing, there's a chance that you can get a good result. This client happened to be a pro bono client, but even for a paying client who has enough money to pay for an attorney, getting that attorney involved, even in a debt case that looks straightforward, could ultimately prove to be beneficial to the individual debtor. So that is my first case study. I hope you enjoyed hearing about that. I'm going to do future case studies as well, but that is a typical debt defense case study, one that was successful for my pro bono client, and she doesn't have to worry about that anymore. She's on a fixed income, she's elderly, not working, and this is one less stress that she has to have in her life. If you'd like to talk to me about a matter that you have in your life, especially if it's a consumer matter or a family matter, please feel free to give me a call, 713-780-7745. Again, I'm Benjamin Sanchez. I'm a Texas attorney. I look forward to speaking with you again. Enjoy your day. Bye-bye.